Hi, and greetings from Lawrence, Kansas. I'm Joseph Mastrosimone, the Associate Dean for Academic Affairs at Washburn University School of Law in Topeka. I'd like to talk to you a little bit today about how somewhat little known provision of the National Labor Relations Act applies to the current COVID-19 pandemic issues and the pressures that it's putting on employment. Please note that obviously the National Labor Relations Act is not the only statute that's putting pressure on the employment relationship. There's a host of legal issues that's arising in employment. I want to talk about just one small piece of that today, and that's the National Labor Relations Act. It seems fitting to talk about the National Labor Relations Act. We're in this period of time when we're told to stay distant, to stay apart, to separate. At the same time, we're told that we're in this together, that we're doing the separation to help achieve social aims. We are acting together. We are acting concertedly to protect individuals in society and society as a whole. And given that context, it seems appropriate then to focus for a few minutes on the National Labor Relations Act. It is unique in that it is the only statute in federal law that deals and protects specifically with times when employees are acting together to protect themselves, acting together to protect labor as a class. And therefore, it is appropriate to look at how that statute applies in terms of today. It doesn't take too far to find NLRA issues in today's news. Take, for example, Amazon. A few days ago, there was a work stoppage at its facility in Staten Island, New York. Employees walked out on the job to protest unsafe working conditions related to COVID-19. And Amazon ended up terminating an employee who was organizing that workplace stoppage. The Amazon has arguments for why that was legitimate. The employee apparently, allegedly, did not return to work after he was told not to because he was exposed to COVID-19. And that was the reason for his discharge, so says Amazon. And Amazon might be right. Amazon might ultimately win the legal battle here. But the critical point to consider is that that may not matter. That is the court of public opinion that this is going to be litigated in, and not the sleepy halls of the National Labor Relations Board or even federal courts on appeal. Take, for example, the tweet from Senator Bernie Sanders here, calling Amazon out for its actions and siding with the employee who engaged in the actions. Amazon's not going to be alone in seeing this kind of reaction from its employees when there's allegations that there's unsafe working conditions related to COVID-19. So what's the legal backdrop? What's the law that's behind the scenes? Well, here in the Amazon case, it's primarily Section 7 of the National Labor Relations Act. And Section 7 is the central promise, the central right of the statute. And it provides employees with the right to engage in concerted activities for the purposes of collective bargaining or, quote, other mutual aid or protection. And it's that provision here that's really coming into play. A few things to note about the Section 7 right. So first, employees do not need to be represented by a union in order to have a Section 7 right to engage in this activity. This is a right given to all employees who are working for employers who are engaged in interstate commerce. The person must be a covered employee, obviously. That in some sense, that means they can't be an independent contractor. That's an easy line to draw. Of course, that does carve out all of our gig economy workers who are often classified as independent contractors. And the employees must work for a covered employer. There are many exceptions for coverage under the National Labor Relations Act. The largest is for government employees. So federal workers and state workers and local workers are not covered by the statute and must find protection elsewhere. Obviously, the employees, by the terms of Section 7 and the nature of the statute, must be working in concert. They must be acting together. It usually takes two to tango here, although you can envision scenarios where one employee can be acting in concert. So, for example, the employee could be asking others to join him or her in concerted activity. They could be bringing group concerns on their own to management's to make that aware to management. They could be making group concerns aware to the public. An important thing to note here also about Section 7, it doesn't just cover strikes. So the employees in Amazon walked out, but they didn't have to. They could have done other things and still found Section 7 protection had they gone to the newspapers, had they taken to social media, had they engaged with state and local authorities. That all would have been protected concerted activity under Section 7. They must be acting for mutual aid or protection. Obviously, that what they're doing must be related to work in some way, either related to their own terms and conditions of employment at their own place of employment, or in a sense to better the lives of workers as a class, as labor as a class. That would also be mutual aid or protection. And then the action must be protected. So employees can't engage in illegal conduct and then hope to cloak that with the protection of Section 7. So workplace violence would not be protected. Other exceptions could be seen. Disparaging the employer's product would not be protected product, but speaking disparagingly about the employer's policies or safety protocols at work, that would be protected conduct. When we're talking about safety concerns and Section 7 actions, mostly dealing with workplace stoppages, so long as the employees have a subjective good faith belief that there's a safety concern, then Section 7 is going to easily apply. Fairly low bar there. One caveat, one warning here to employees: if they go out on strike, if there's a work stoppage, for these reasons here, this would be considered an economic strike, an economic work stoppage, and therefore the employer would have the right to permanently replace those employees. They could not be discharged, but they could be replaced so that when the work stoppage ends, they would have to wait for a job opening to occur before they would get an opportunity to have their job back. The employer would not be required to discharge the replacement workers. Juxtapose Section 7 with Section 502 of the NLRA, a bit of a sleepy section of the statute. It doesn't get a lot of play except in times like this. It got some play when Ebola had an outbreak a few years ago. It even got some play during Y2K. And here we are again with COVID-19. So Section 502 essentially says, look, employees who go out, who quit their work because of a good faith belief that there are abnormally dangerous working conditions at work, we don't consider them to be strikers. So what does that mean? What's the practical effect? Well, that essentially provides those workers with some enhanced protections. If they're not strikers, then they can't be replaced as strikers. And so they could not be permanently replaced. They can't be discharged. They can't be permanently replaced. They have some extra protections that the Section 7 strikers, economic strikers, don't have. Well, along with the extra protections come with some extra burdens of proof. So a Section 502 strike would be found only when the employees believe in good faith that working conditions are abnormally dangerous, not just dangerous, but abnormally dangerous. That the belief is a contributing cause of the work stoppage. It doesn't have to be the only cause. There can be others, but it has to be one of them. That the belief, and here's the kicker, is supported by ascertainable objective evidence. It's not enough, unlike in Section 7, for the employees to have a subjective good faith belief, but it has to be backed up by some objective evidence. And then finally, that the perceived danger imposes an immediate threat of harm to employee health or safety. Don't read too much into immediate. The board has said that that can be over a longer period of time. For example, a low-level exposure to radiation over a long period of time. The cumulative effects of that, the board has said, poses an immediate threat to harm, even though it's not an immediate cause and effect. How does all this apply here to COVID-19? You can see easily the arguments that employees could make. If there's a work stoppage, imagine an employee is diagnosed or a member of their family is diagnosed with COVID-19, and then the employees walk out thinking that the workplace is now an area where they can, where the virus can be transmitted. Are they working in abnormally dangerous circumstances? No, they're certainly more dangerous than normal. You would not normally expect in an average workplace to be exposed to a deadly disease. That seems abnormal in the common sense meaning of the word. Is the belief a contributing cause of the work stoppage? Probably, as long as if there are other things at play, that's fine, as long as it's one of them. Is the belief supported by ascertainable objective evidence? Are they just being irrational? Is there an irrational fear? Given what we know so far about the disease and how it's transmitted and the serious consequences for some that are diagnosed with it, there seems to be enough support that it's not irrational, that it's not just subjective, that it's based on some objective evidence. And is there a perceived danger, an immediate threat of harm to health and safety? Well, sure, yeah. If long range low dose exposure to radiation is sufficient, surely a 14-day incubation period is probably more than enough to meet the immediacy of the statute. These are important things for both employees and employers to think about. These are rights that employees often forget that they have or never knew that they have, particularly on the Section 7 end of things. They think, well, they're not part of a union, so they're not protected. Not so. These are rights inherent as employees covered by the statute. And to the extent that Section 7 isn't well known, Section 502 is barely even given a second thought by employees. But it's important that they know they have these extra enhanced protections, but that there's extra enhanced proof that must be provided. So careful counseling of employees is important here. Same too on the management side, on the labor side. Employers should be well aware that employees have both Section 7 and 502 rights here. If employees are going to the press, if they're going to public, if they're going to social media to complain about employer safety, COVID-19 exposure, cleaning protocols, that's protected by Section 7, so long as that they are engaged in protected activity. They're not doing things outside of bounds. That's protected, and those employees could not be discharged or they could not be disciplined. Same on the 502 end for work stoppages. The 502 certainly is going to limit the employer's response and how it responds to a work stoppage. I hope you found this very quick video helpful. There's certainly more information out there about both Section 7 and Section 502. There's information here on the slide. I hope everyone is well, remains to be well. Hope you found this informative. Special thanks to Professor Rubenstein for being the leader in the faculty colloquium on COVID-19 and its effects on the law, and to Glenn Macbeth for putting together all the technology on the backside. Thank you. I hope you enjoyed it.